Good morning. I'm Luis Páez, and I'm very happy to be here with my professor, David Rudovsky.
Morning.
Good morning, professor. How are you? I'm very happy to have the chance to talk to him today, just to have a small conversation on some topics that I feel are particularly important for practitioners and people in academia in Colombia who may be thinking of trying to learn a bit of what's happening in the US, a bit of like the foundations and things like that I feel for some people they could feel like very far away, but they're rather less far away than we think. Professor Rudovsky has been a professor at the University of Pennsylvania Law School since 1987 of courses such as criminal law, evidence, criminal procedure, among others. And in parallel, for over 40 years, he has practiced the civil rights and criminal defense fields, including cases that have to do with police and governmental misconduct, prisoners' rights, and racial discrimination. And again, I'm very happy to have him here. Professor, how are you?
I'm good. Great to see you again.
I'm very
one of my favorite students.
Oh, you! That's so nice of you. So, Professor, coming to Penn and taking your class, I had, of course, some preconceptions of how U.S. criminal law and criminal procedure would work. Some of that would be through the data that I would research beforehand. Some of that, I have to admit, will also come from the images that we get from some TV shows and movies over there, come from the US. But something that struck me in particular from the very beginning was the fact that in Colombia, when we talk about criminal procedure as a course, it's usually just criminal procedure law. It's not constitutional criminal procedure, even though in our case, we still, that there's a very heavy component of constitutional provisions that we have to study. So it struck me that here, when I wanted to take your class, it was going to be called constitutional criminal procedure. And I think that there's a good reason for why it's named like that. I later found out that almost like in every law school in the US, it tends to be known as constitutional criminal procedure. And I wonder if you could perhaps explain to Colombians why that is.
Yes, so it's a really good question, and it emanates from the fact that, as a bottom line, in terms of rights of criminal suspects and persons who have been arrested in the United States, much depends on the U.S. Constitution. The Fourth Amendment talks about searches and seizures, requires warrants and probable cause before the police can conduct a search that invades privacy. The Fifth Amendment protects against what we call self-incrimination. The Sixth Amendment gives the right to counsel, the right to confrontation, and so on. And we've got an interesting system here. We've got a federal system of criminal justice, and obviously there's federal rules of criminal procedure, like civil procedure, which talk about discovery and venue and charging and so on. But does not provide any substantive rights in terms of privacy and self-incrimination and counsel. That's all constitutionally based.
Right.
And then we've got 50 states, each with their own constitution, each with their own sets of criminal procedure. And then within those states, for example, Pennsylvania, there are 60 counties, each with separate police forces, separate district attorneys. So a very kind of complicated federalism system. And the result is that in all criminal prosecutions in the United States, the U.S. Constitution creates a minimum, a floor of due process, equal protection, and counsel rights.
A baseline.
A baseline. So you've got the Fourth, Fifth, and Sixth Amendment, then you've got the 14th Amendment, which talks about no deprivation of due process, of liberty without due process, and equal protection of the laws. So you've got within the Bill of Rights in the United States a number of substantive protections, and that's what we teach in constitutional criminal procedure. Because from the prosecutorial side and from the defense side, both investigators, lawyers, participants in the system have to know, right, what the limits are. And as part of that, as we'll talk about, where rights are violated, it's possible that the courts will exclude evidence from that. And on the civil side, there may be civil actions against law enforcement and prison officials who violate suspects' rights.
Right. Thank you, Professor. We will delve later more into constitutional, the exclusionary rule and the relation that has with constitutional criminal procedure. I first wanted to ask you, however, I know, and perhaps you can correct me if I'm wrong, but from everything that we learned in your class of criminal procedure, my impression was that the Supreme Court of the United States, the federal Supreme Court, so to speak, this court, the way that they go into like a lot of detail of how, for example, like police conduct should or shouldn't be in very particular cases. Now in Colombia, we have a criminal procedure code, which is over 500 articles long. It definitely has to do with the fact, even though we had a reform that made our system adversarial and perhaps more similar to the US's, we're still very much law-based civil law country. And in that sense, we have a code, like a long code that tries to set out every possible, as much as it can, every possible scenario and situation and tries to regulate it. Yes, we have a Supreme Court and the Constitutional Court that tried sometimes to interpret, and then later that becomes also the law or how it must be interpreted. But the code is there. And I feel that it just doesn't happen as much as here, that the Supreme Court is taking care of situations in such detail, such as to say whether a police officer should do this or that. I don't know. Maybe you could talk a bit about that.
Yeah. So it's opposite sides of the coin. Here we go from the general to the specific, right? And when I talk about general, the principles in the Constitution are really general. So the Fourth Amendment talks about there shall be no unreasonable searches and seizures, right? And search warrants shall not issue except probable cause. But what does that mean? What does it mean to be an unreasonable search and seizure?
Right.
The Fifth Amendment talks about the right against self-incrimination. Well, what does that mean? Sure, it probably means that you can't compel somebody to testify at a criminal trial. But what about pretrial interrogation, right? And the Miranda rule that we have. Right to counsel. Says there's a right to counsel. The Supreme Court's had to deal with the question: if you have a right to counsel, what if you can't afford a lawyer? Does the system have to pay for appointed lawyer? We know the answer to that is yes. When does the right to counsel attach? When you're first a suspect, when you're arrested, when you're charged. At the beginning and at the end, how long do you have a right to appointed counsel on appeal or on post-conviction attack? The Eighth Amendment prohibits cruel and unusual punishment. Well, who's to determine what's cruel and unusual?
Right.
Very general.
Very abstract.
And so what we find here is case by case where defendants make arguments that their rights were violated. The court then has to kind of get into the kind of detail that you start with, right? And then gets applied in those cases. So it's two ways of addressing it. And here it goes from the general to the specific, which is why on any particular issue, you could have hundreds of lower court opinions. And eventually the Supreme Court, if there's not an agreement as among the courts of appeals and so on, has to decide what the rule is. And even then they start with kind of general applications. So in Gideon versus Wainwright, they said, in a serious felony case, you have a right to appointed counsel. Or what about misdemeanor cases? Or what about cases that aren't that serious?
Right.
When do you have a right to a jury trial? All cases? Does it have to be 12 persons unanimous? And so the court's got to deal with all those details, which it does in case after case.
Correct. Thank you, Professor. Now to perhaps jump into a bit of a different subject. You often hear in Colombia that our criminal justice system is in crisis. We face very tough issues on prison overpopulation. which are just terrible. We also, however, like even though that's happening, it's also true that prosecutors usually have huge backlogs of cases that are unresolved. Part of the reason why we had uh, this reform that we've talked before, the law 904 of 906 of 2004. Part of the reason we had this reform in 2004 was there was an understanding that our systemic slowness, so to speak, of our system could be improved if we took aspects from the adversarial process from the US and from other systems as well, but there was definitely a big influence from the US. And the idea back then, in 2004, was that this will help us improve how quick justice can be. Today is, I mean, it's been over 20 years already, and we still are facing these kinds of issues. Um, and people, even today, still sort of look towards what happens in the US from very far away. And the usual thought is that, oh, they must do it better. They, I mean, plea bargains, that has to go like real quick. Everything must be much more efficient, much more pragmatic. You guys are not set back by, tautological discussions regarding, but what is the real law here and the interpretation. Rather, you just are, you're more doers than staying and thinking what to do. And so that's like the image. But I'm also very aware, and I would like for you to talk a bit about what do you think are the main issues of U.S. criminal justice and U.S. criminal procedure, in summary, and whether you think that vision that so many people over there have of the U.S. criminal system, whether it's that nice or that quick or that efficient in that sense.
Well, you don't want to buy our system. We have a lot of the same problems. We address them somewhat differently, perhaps, than they're addressed in Colombia, although maybe it's starting to merge a little bit. Number one, here, in terms of the division of labor, prosecutorial side, you've got police forces, federal, state, local police forces that build cases. When it's an investigation of a crime, they're the ones that investigate, they make the arrests, so on and so forth. And often, unless it's a very serious, complicated case, without any advice from a prosecutor, they decide who to arrest, who to charge. It's handed to the prosecutor, so the investigation is pretty much complete. And then the prosecutor's got to deal with that, right, in an adversary system. There are speedy trial rules, right, which put some pressure on the system to try cases in a timely way, or else charges might be dismissed. There's a lot of loopholes there. There's some people that can spend a year or two in prison before they actually have a trial. But given the huge number of arrests and mass incarceration, the system relies a lot on plea bargaining. And it'd be interesting to see what the system is in Colombia. In virtually every case that I know of where somebody's been charged, there is some discussion at some point about resolving that charge with a guilty plea. In fact, today in the United States, between state, federal, and local prosecutions, millions of prosecutions each year, over 95% are resolved a guilty plea, often with some kind of negotiations between the two sides. And that could be negotiations about how serious the charge. It could be negotiations about how much time you spend in prison, so on and so forth. And it's got its critics, it's got its defenses. I'm not totally against plea bargaining if both sides have the resources to do it and the case is well investigated. And you can reach an agreement. That's often a fair resolution of the case. But the image of the United States, with from the movies and the books about these spectacular trials that go on for weeks, right? With big forces on both sides and jury trials, that's the exception to the rule. More and more cases resolved in the plea bargaining process, and the problem there on both sides is the number of cases, not enough lawyers, right? From the defense side, certainly often not sufficient funding for public defenders. Public defenders are assigned in 85 to 90% of the cases, people are too poor to hire a lawyer. So you've got a system on the one side of professional prosecutors and then professional defense lawyers and in public defender offices. Some do a spectacular job because they have the resources and training to do it. Others are completely overloaded, right? Which means a lot of people plead guilty with very little investigation of their case.
Right.
Particularly if you're in prison, and this is irony here, right? So somebody gets in prison, it's not a serious charge. Let's say theft, bail is $5,000. You got to put up $500, 10%. You can't afford it, right? And so the prosecutor comes to the defense lawyer and says, "Look, you guy's been in prison for a week. He won't have a trial for another 2 months. If he pleads guilty tomorrow, we'll agree to time served a week." Well, put yourself in the position of the defendant and the lawyer in that kind of situation and assume you're innocent, right? Are you going to kind of spend the next 2 months or take the deal, right? So a lot of pressure, right, to do that. Doesn't mean all those people are innocent. That's a fair deal. But why is it too risky to release them on reasonable bail at that point, as opposed to releasing them on a guilty plea, right?
Right.
If he's a danger, he's still a danger. So it's got its faults, and it's structural. And we've got a system which a lot of people call mass incarceration. Huge numbers of people in prison here, certainly compared to Europe and so on. It's gone down somewhat, but early 2000s up to 2008, 2010, over 2 million people incarcerated, the 5 million people under parole or probation supervision, a huge system of control of people. And what we found over the years also is conviction DNA testing, right? Sometimes we get it wrong, right? People convicted of very serious crimes, and on the usual evidence we use, identification, confessions, jailhouse informants, forensics. Turns out a lot of that turns out to be not true when we re-examine. So when you compare our system to others, and you say from the South, you look north and you say they seem to be doing it better, I doubt.
Okay. It's very interesting now that you mention it. You mentioned bail in the bail system, and perhaps how it works. Just to make a quick comment on that, in Colombia, for example, we have a system. It's also an adversarial hearing. There's a hearing that must be carried out before somebody is officially into what we call medida de aseguramiento. And in that hearing, the defense has a chance to present evidence in favor. The prosecution has a very big obligation to present its own evidence.
Mm-hmm.
Some people in Colombia call it like a mini trial in that sense. And so there's a chance for the defense to defend itself against the whatever charges at a very early stage are being investigated. And so sometimes that can help the defense. Sometimes that means that the defendant won't have to go to jail right away. Still happen. I mean, I would say, and many people in Colombia would say that it's still very much a thing that there's a lot of people that go into pretrial detention. And I think that people in Colombia, practitioners and perhaps academics, usually don't really think too much about how bail system works in the US. I don't know if maybe I could get your comment on whether you think maybe that there could be some economic discrimination happening there with the bail system, where it's inherent, whether it's good in some way, but not advisable in other ways.
Yeah, whenever you require money bail, you know you're going to have kind of economic differentiation, right? So take two people similarly situated, same kind of background, work, family, charged with the same kind of theft from a store, have the same past criminal record, if any. One is fairly well off, the other is not. And the judge looks at the case and says, let's just say $5,000 bail or $2,500 bail. Turns out here you've got to put up 10%. So for one person, it's easy. He's got the $50 or $500 that he needs, right? The 10%. The other one is impoverished, doesn't have it. he'll wind up in custody and wait and then have the pressure to plead guilty. And the other person is out, can help his lawyer, right? And you see different results. People out on bail do better statistically than people who've been incarcerated, controlling for all the factors in the case. So that's a huge issue in the United States, and it's part of the mass incarceration. A lot of people are waiting trial, not yet convicted. There are some protections. There is a bail hearing, but it's very early on, and often the judge has very little information about the defendant. It can be reviewed later and reduced, but you've still spent some time. There's also a requirement before the case goes forward that you either be indicted by a grand jury or that you have a preliminary hearing where the state has to show probable cause that you committed the crime, but that's a very low bar.
And that doesn't happen in every state, right?
That's right. It doesn't happen. It's often just based on some affidavit from a police officer. It doesn't get much protection. Some cases are screened out early where there really is no evidence at all, but most go on to the next stage and plea bargaining and then possible trial. So it's a very difficult question about the determination of how much the state has to produce up front when they may not have all their evidence at that point, and then what a judge should do on that critical question of whether somebody's incarcerated or free pending a trial sometime later.
Professor, just to get your take and to finish this subject that we're touching on right now, you mentioned that there's a mass incarceration problem in the US. Now, perhaps to provide you with a bit of context, I feel that Colombia faces and has faced historically issues with high crime rates, urban, rural, and that has meant there's many reasons for that. It's perhaps more of a criminological discussion, but today, I would say that there's still, maybe even understandably, a big part of the population that would probably not think twice to get as many people as they can in jail, because in their minds, it would seem to be like the only reasonable thing to do when you have so much crime happening. Now, since the US has an over-incarceration or mass incarceration problem, I would like to get your take on whether you think that getting more people in jail is going to result in less crime. I know it's a very complicated subject. I know it's perhaps more criminological. I know there's huge discussions on many of the reasons around it. But perhaps with your experience as a practitioner through so many years, you can tell me what you think about that overall.
Yeah. So you've got to kind of divide the world here. Certainly, you're right. If people are thinking about violent crime and they hear a lot about robberies or rapes or murders and so on, they think, lock them up for a long time. But it turns out, at least in the United States, a lot of the mass incarceration is generated not by that. For many years, it was the war on drugs. The number of people arrested and charged with simply possession or selling small amounts of drugs was enormous, right?
Right.
Hundreds of thousands, millions of people prosecuted each year. Not all went to prison, but a large number did, even minor crimes. And then because of the concern about crime, we had what were called, require mandatory minimums, right? So for a serious case or for recidivism, second drug case, instead of, some option for the judge, you got to do 5 years or 10 years. And then in many states, things like felony murder, even if you're not involved in the shooting, right? You were the getaway driver, life without parole, plus the death sentence, which we have here. And so when you think about that, and really what we've learned is, contrary to what a lot of people think, that the more people you lock up, right, the safer you'll be. It turns out that crime has come down with fewer people in prison. Seems counterintuitive, but that turns out to be true. And so you've really got to be much more careful and target those who really are a danger, but not forever. In Europe, it's rare that somebody gets more than 10 or 15 years in a particular case. People age out of crime. We know that people, when they're in their mid 40s, 50s, and later, right, there's very few crimes, and yet we have an aging population here because of mandatory and life sentences. People spend entire lives, decades and decades, in prison, which leads to the over incarceration. And so, yes, you've got to be effective, but you got to be smart on crime also. And you've got to be much more selective in terms of who you punish. Sure punishment is better than long punishment, right? If you can target those cases where, in fact, somebody's committed the crime, figure out what's required for public safety and some rehabilitation, which is almost never really done in our prisons very well. Some people rehabilitate themselves, but it's almost by chance. It would be much more effective, and I think people would feel safer.
Thank you. Thank you for that, Professor. To perhaps then touch upon some of the main criminal procedure subjects that I wanted to discuss a bit today. The first one is the exclusionary rule. Again, just as context. When we had this big reform in 2004, which was influenced by many actors, the US, USA, Colombia then enacted a new criminal procedure that, again, sought to improve the situation. It may sound strange to you, but we've had, I think, since 1938, we've had over 7 or 8 criminal procedures, because oftentimes that maybe has to do with the culture, the juridical tradition that we have. We think that changing the code will help improve the reality, or changing the laws improves the reality, and that's like our take on that. As part of this reform, we also then try to sort of import figures into our system, and with the hope that they will help us have a better working, functioning system. And that's where the exclusionary rule comes into play. Now, you just heard me say 2004 exclusionary rule, and I know that in the US, the exclusionary rule has a way longer history. And as we saw in our class and our courses, it may even be the case that by 2004, here in the US, the exclusionary rule maybe wasn't all that, at least to the Supreme Court. So maybe if I could get your take on what the exclusionary rule is, and a bit of like the historical development until like what do the current Supreme Court you think thinks of it?
Yeah, so the exclusionary rule really revolves mainly around our Fourth Amendment, which controls the question of police arrest, search, and seizure of suspects. And as I said, the Fourth Amendment is kind of interesting. It says there shall be no unreasonable searches and seizures, and that search warrant shall not issue except upon probable cause. That needs a lot of definition. But early on, the Supreme Court ruled, and this was more than 100 years ago, first in federal prosecutions and then in state prosecutions, as well with the 14th Amendment and incorporating the Fourth Amendment as the federal government, that if the police violated the Fourth Amendment under whatever particular theory it was, they didn't have a search warrant, there weren't exigencies, they didn't have probable cause, they came into your house without any reason and found evidence of criminal conduct, that the court would suppress that evidence, exclude it from trial. That is, the prosecution couldn't benefit, right, from the wrongdoing of its police officer, both as a kind of question of fairness and one of deterrence. If there's not an exclusionary rule, why shouldn't the police just randomly, right, go about searching and seizing anybody they want? That's the theory. And at first, it was quite robust, and there was a pushback on that. Why should the public, right, be punished for the wrongdoing of an individual officer? As Cardozo said, the officer blundered, and therefore we can't use when it's valid evidence. We found the drugs, we found the stolen property, we found the weapon, right? This is question of whether it was planted or
Right.
unfair.
And it's usually incriminating evidence. If we're
Yeah.
dealing with that,
And
it's
it's
going to be
obviously
incriminating.
And so what you found is, not surprisingly, that in minor cases, a small amount of marijuana was found. Judges were willing to suppress the evidence. If it was a murder case or a sexual assault case, much higher burden, practically speaking, on the defense side to get it excluded. And in fact, the court started to build in exceptions to the exclusionary rule. Police acted in good faith in what they did. It wouldn't be used in parole hearings and so on. So it's been limited by the Supreme Court, but still. And then you get this pushback by the states. We have states like Pennsylvania that have a more robust exclusionary rule because they have their own constitution. But the principal theory is it's a question of deterrence. There are costs and benefits, obviously, that are involved. But that in the exclusionary rule, you're really in the Wild West.
Right. I wonder, what do you think, in your opinion, with the current Supreme Court, what could be the future of the exclusionary rule?
It hangs in the balance. It was the Warren Court, which is a very liberal court of the U.S. in the 1950s and 1960s,
Right.
that first required the exclusionary rule of the states and had some pretty robust provisions. That's been cut back. I think the current court, if it had its way to start over and without stare decisis and reversing those early decisions, probably might not even opt for an exclusionary rule. They would say there are other remedies. Police can be prosecuted if they do something criminal. They could be subject to internal discipline. They can be sued, right? There are other provisions there.
Supposedly other solutions that wouldn't harm the general population,
That's right,
of not admitting the incriminating evidence.
and still deter. But the question is, are any of those real, right? And unfortunately, while there are civil suits or some criminal prosecutions, I continue to think unless you've got a pretty strong exclusionary rule, you're going to have a lot of misconduct in the cases. Now, we've also learned, it's interesting with the DNA revolution and post-conviction DNA testing and finding out that a lot of convictions are wrongful, even in serious cases, very serious cases. There have been some adjustments made by police departments. So, for example, with confessions, it turned out that 25% of post-conviction DNA testing that showed the person was innocent, the person confessed to a
25
or rape.
25%,
right? And so now you've got states and police departments who videotape, from start to finish. So we see what's going on behind closed doors.
Right. What used to be behind closed doors for a long time.
That's right. Eyewitness identification. 75% of those cases, witnesses were wrong. They weren't lying. They weren't deliberately trying to get somebody convicted. They were just wrong in their recollection, or it was a matter of recollection plus suggestiveness by the police and showing photographs through a lineup. And police departments have started to make some adjustments there as well. Bad forensics, right? DNA is the gold standard. People convicted of bite marks, it turned out the bite mark was by an animal, not even by human teeth. Even fingerprints are questionable. So we learn more, even without the Supreme Court intervening. Some more progressive departments, police chiefs, and so on, have kind of voluntarily said there are better ways of doing it. So you hope the combination there improves the final result.
Right. Thank you, Professor. Having touched a bit on the exclusionary rule, I would like now to again touch on plea bargains. As I mentioned before, with the reform, we also tried to bring plea bargains into our system. Before this adversarial reform that we had very much influenced in the U.S., we had negotiation frameworks. They used to work variously, but certainly with the reform, plea bargains became this big institution called preacuerdos in Colombia. And again, the idea behind them was that we need quicker justice, we need faster justice, things are extremely slow, huge backlogs. How to fix this? Well, let's do what we see that also happens there. It's just much quicker. Like prosecution and defense just negotiate whatever they have to negotiate so that they get a quicker sentence. I wonder, I'll ask further questions, but first, could you explain, in your opinion, in your knowledge, what a plea bargain is in juridical terms and what your opinion on it is?
Yeah. So as I said before, we have a system of plea bargaining. Most of the cases, people wind up pleading, often pursuant to some kind of negotiations, either the DA dropping certain charges, or agreeing to a particular sentence for whatever the person pleads to. The judge has to agree to that. All of which could work well, as I said before, if we had equality of resources and full discovery, right, before somebody has to decide whether to plead guilty. We've got the pressures of being in prison and they want to get out. So a lot of fault lines in our system. As I said before, the theory works by theory, but not always in practice.
Right.
You had sufficient time, well-resourced defense lawyers. Both sides knew the strengths and weaknesses of the other side's case. We did more investigation, background of the person, decided what's an appropriate sentence or charge, because people are always overcharged to begin with. Everything is thrown up there, hoping it will stick. And then to kind of reach that final resolution and do it in fairness compared to, an adversary proceeding to trial, which is also questionable, right? Whether a judge or jury is going to get it right one way or the other. That can work, but what we find too often in the United States, you've got unequal resources, and the pressure is on the defendant to plead guilty, often without full knowledge of what he or she might be able to do in trial, and often under the threat of mandatory minimums and so on. So the prosecutor says to you, if you plead guilty, we'll withdraw the mandatory charge. If you go to trial, you'll have the trial penalty, right? So you could do a year under the plea, but if you go to trial with the same evidence, there's a 5-year or 10-year mandatory. The judge has no discretion at all. Pretty good weight on the prosecutorial side. So there's this imbalance,
almost coercive,
that's been created. So that's how it works.
In this context, Colombia tried to import plea bargains and has tried to apply them. Now, it may be a difference in, again, juridical traditions and how things work, but what we've seen in Colombia is that subsequently there have been limitations put on plea bargains. Some of those have come from legislative reforms. So, for example, things like crimes that would affect underage minors, later crimes that maybe have to do with domestic violence, had to do with public corruption, even limitations like if you're going to do a plea bargain, you have to move inside this range, and that has been happening. And in parallel, decisions from the Supreme Court and the Constitutional Court have, to say the least, often being very much zigzagging on these kinds of limitations. And the end result of that is that it makes for a very hard, difficult to put down in practice what the ranges and the limitations and how to apply plea bargains. I know that there's 50 jurisdictions here in the United States, but just to get your take, what would be your opinion on, for example, judges or maybe even legislators routinely getting themselves involved inside plea bargains? Because I feel that here there's more freedom, more prosecutorial discretion for prosecutors to do their plea bargains, right?
Yeah. So there is, in one sense, although every plea bargain has to be okayed by the judge,
right,
in every jurisdiction. And jurisdictions, and there are some states, because of this whole debate about plea bargaining, and people thinking, boy, the defendant does really well, right? a plea bargain, he gets the better of the bargain, right? That's why I call it plea negotiations. I'm not so sure it's a bargain, right, on one side or the other. Uh, and because of that, some states have prosecutors have said, "I'm not going to plea bargain." Well, yeah, they say it, but they do, right? Because otherwise they're stuck having to do trials, right, in thousands of cases, right? And the backlog would be enormous. Case would be dismissed because of speedy trial rules. You can't have it both ways unless you're going to spend billions more for more prosecutors, more judges, right, more jails, and have everybody or a lot of people go to trial. And the jury trial, right, take 2 weeks. Bench trial could take a day. A plea bargain could take an hour or a plea. You're faced with that problem. So even in places where prosecutors said, "I'm not going to plea bargain anymore," right? It's too soft. The system,
Right.
you find it goes on. And so, if that's true, you really have to find a way to make that system fair and effective. And some places it's better than others. Yeah.
Thank you, Professor. Another subject that I wanted to touch upon
Yeah.
has to do with the fact that in Colombia, prosecutors not only have to prosecute individuals, but also have to investigate. They're the ones that order detectives to go out and search for evidence and so on. And I feel, in my opinion, having learned a bit of what happens here, that that's a very big factor in why there could be huge backlog of cases. Prosecutors just have too much to deal with in that sense. And I know that's different here in the U.S. Like prosecution is more focused strictly on the judicial prosecution side, correct?
Yeah, so the great majority of cases, as I said, are investigated by the police, federal PI, drug enforcement, state police, could be local police, and whatever the crime, theft, drugs, robbery, serious crimes like murder, right? Those are all initially investigated without much prosecutorial input. As I said, some cases that are very complicated, they go to the grand jury for investigation, where you've got public corruption and a lot of different resources that might be needed. Prosecutors might advise, right, police on how to proceed, review search warrants,
Right.
and things like that. But 98% of the charges that are brought, prosecutor has no input before the charges are brought in, and then they pick it up at that point. Sometimes with more investigation, they've got to turn over exculpatory evidence to the defense. That's a constitutional right, but you've got that division of labor.
Correct.
And so, but you have the same impact either way. It's where you're going to spend your money and your resources, right? So here we'll spend a lot on police forces, right? And the initial investigation and give them the resources to do it. And then maybe we need fewer prosecutors, right? Because they don't have the double burden of both investigating and then prosecuting in court and negotiating in those cases. So it may be somewhat of a wash, right? And the question is, how much are we willing to spend in our system, right? And then for the defense side, obviously, for defense lawyers and their investigators and their experts, to make sure you've got a balance on both sides there. Um, that's kind of more than a theoretical question, right? But here we've got this tradition, an adversary system, right? Police investigate, give it to the prosecutor, and then you've got the adversarial process that starts there with the judge supposedly being a neutral arbiter.
Well, Professor, thank you so much for your time. Thank you so much for everyone that is perhaps interested in these subjects. I feel like I learned a lot with Professor Rudovsky, who was my teacher in the courses of constitutional criminal procedure and evidence. And once again, thank you for being here and have a good day, everyone.